Washington. Special counsel Jack Smith asked the Supreme Court Monday to rule quickly on whether former President Donald Trump can be tried charges that he plotted to overturn the 2020 election results. Smith asked court move with unusual speed to avoid any delays that could delay trial of frontrunner in 2024 Republican presidential primaries, which are scheduled to begin March 4, until after next year's presidential election. Later Monday, the justices said they would quickly decide whether to hear the case and ordered Trump's lawyers to respond by Dec. 20. The court's brief decision gave no signal of what it would ultimately do. A federal judge ruled the case could move forward, but Trump said he would ask the Federal Appeals Court in Washington to reverse that conclusion. Smith is trying to bypass usual next step in process, appeals court, and have Supreme Court address issued directly. This case raises a fundamental question at the heart of our democracy: whether a former president, completely immune from federal prosecution for crimes committed while in office, or whether he is constitutionally protected from federal prosecution if impeached but not convicted before criminal proceedings begin, wrote Prosecutors. Trump's presidential campaign criticized Smith for trying to circumvent the appeals court. There is absolutely no reason bring this to trial other than harm President Trump and tens of millions of his supporters. President Trump will continue to fight for justice and oppose these authoritarian tactics, the campaign said in a statement. The court is next scheduled to meet in private on January 5, 2024. It's unclear whether the justices will meet sooner to consider Smith's request. Smith and his team underscored prosecutors' urgency to find a speedy resolution would move case forward, writing it is of vital public importance that the defendant's immunity requests be determined by this court and defendant's trial proceed as expeditiously as possible. The immunity request is denied. At issue is U.S. District Judge Tanya Chutkan's Dec. 1 decision rejecting arguments from Trump's lawyers that he is immune from federal investigation. Chutkan, who was appointed by President Barack Obama, wrote in his order that the presidency does not grant release from prison for life. Former presidents have no special circumstances regarding their federal criminal liability. Chutkan wrote, if justices step in, they would have the opportunity for first time to decide whether former presidents should enjoy immunity from prosecution. Justice Department policy prohibits impeaching a sitting president, although there is no such bar against prosecuting a former commander-in-chief. Trump's lawyers say he cannot be indicted for actions that fall within his official duties as president. Prosecutors vehemently denied this claim. Smith's team emphasized that if court does not expedite matter, there will be no opportunity to evaluate and resolve problem incur.